Not without Parliament. Britain's Supreme Court says the government must consult Parliament before starting Brexit negotiations. So how will this affect the so-called hard Brexit? And what does all of this mean for the UK? This is Inside Story. Hello and welcome to the program. I'm Richelle, Carey. Many Britons who want to stay in the European Union felt a rush of relief on Tuesday when the Supreme Court ruled that only Parliament can say when negotiations can begin to leave the EU. But since then, it's become clear the ruling probably won't prevent Brexit or even delay the proposed schedule. Prime Minister Theresa May was in Parliament on Wednesday, facing off in a heated debate with the opposition. She says she'll publish her plans for Brexit in a formal policy document called a white paper in the coming days.
The House has overwhelmingly voted that Article 50 should be triggered before the end of March 2017. Following the Supreme Court judgment, a bill will be provided for this House and there will be the proper debates in this chamber and in another place on that bill. There is then the separate question of actually publishing the plan that I have set out, a bold vision for Britain for the future. I will do that in a white paper.
So the Prime Minister's schedule may still be on track, but Tuesday's Supreme Court ruling could still have broader implications for future policy decisions and for Scotland and Northern Ireland staying part of the UK. Lawrence Lee sets up our discussion from London.
You can say many things about politics at the moment, but certainly none of it is dull. The scene is the highest court in the UK, where an unprecedented 11 of the most senior judges in the country were to decide an issue of historic importance. Did the Parliament have to have a say on the instigation of the UK's exit from the European Union? And the answer, yes, it did.
Today, by a majority of 8-3, the Supreme Court rules that the government cannot trigger Article 50 without an Act of Parliament authorising it to do so.
Given that the government had insisted that it, as the executive, could do what it wanted with the referendum result without consulting Parliament, this had their many critics, accusing the Prime Minister of being lost at sea. Certainly the people who brought the case demanding parliamentary scrutiny saw it as a victory for democracy.
No government can expect to be unanswerable or unchallenged. Parliament alone is sovereign.
For all that, there was a separate judgment siding with the governments at the so-called devolved assemblies. Governments with limited powers in Scotland, Wales and Northern Ireland could not influence the referendum decision themselves. That immediately prompted Scotland's First Minister to complain her country's rights were again being ignored.
That raises a really fundamental question for Scotland. Are we happy to allow our future to be dictated by a Westminster government with one MP in Scotland, or is it time to take our future into our own hands?
You could argue this is embarrassing for the government, but it certainly isn't disastrous, and they will still pursue their ambition of getting on with Brexit in the coming weeks and months. What it does demonstrate, though, is how badly thought through the referendum was in the first place. If they considered the authority of Parliament when framing the question, it would never have ended up in the Supreme Court. The question now is whether many members of the UK Parliament, who by a majority wanted to remain in the EU before the referendum, will try to oppose the government when they have their chance to debate it.
This will be a straightforward bill. It's not about whether or not the UK should leave the European Union. That decision has already been made by the people of the United Kingdom. We will work with colleagues in both houses to ensure this bill is passed in good time for us to invoke Article 50 by the end of March this year.
So gradually things are being clarified, at least on a timeline. The great unknown is what happens 2 years hence, whether there is any decent deal for the UK with the EU. Parliament will get a vote on that too, whatever it may be. Lawrence Lee, Al Jazeera, London.
Now, before we get to our panel, let's speak to David Greene. He's a lawyer representing one of the claimants, Deir Dos Santos, who was the first person to lodge a legal complaint against Theresa May's plan to trigger Article 50 without a parliamentary vote. He joins us now from London. David, thank you so much. Why did your client bring this legal action?
Because it was a question simply of the process for withdrawal from the European Union. and the point about the court, the case relates to individual rights that derive from membership of the European Union, and how those rights should be affected. And the government started by saying that Parliament would not have a say. We issued the proceedings. As they progressed, the government said that Parliament would have a say, but they would have it at the end of the process. That doesn't particularly help us, so we continued our proceedings, and we got an answer at first instance that the government had to go to Parliament and have a statute in order to serve the Article 50 notice. And the government appealed, and we've just had the result of the appeal. So all along we've been saying this is the way that the process should work, and the court has now said that is the case. And so we've had what have we achieved? First of all, we achieved the consultation with Parliament at the end of the process. One can speculate as to whether that would have happened had we not started these proceedings. And secondly, we now have a process that the government has conceded that it will publish a white paper about its policy before it presents the statute that must be passed by both houses in order to serve the Article 50 notice.
David, why so much ambiguity about how this process is supposed to go? Is it because it's so unprecedented?
Yes, it is unprecedented, and it's a debate about where sovereignty lies. There's no doubt that a government has an entitlement to enter into international treaties under what we call the royal prerogative. But when it comes to rights which Parliament had given, we say that Parliament had to take those rights away. It's only Parliament, under its sovereignty, that is entitled to take those away. So that was a debate, and indeed, one looks at the development of the Constitution, the UK Constitution, over the years, and it remained unsettled on this point. So from everyone's point of view is we should be grateful that the court has concluded where the power lies in these circumstances.
Your client's reaction to this verdict, what has it been?
Well, he was delighted. As I say, he started the proceedings, and then Gina Miller joined the proceedings, and he was delighted with the result because we always only talked about the process. And the one thing this case became confused with was, are we talking about remain or withdrawal from the EU? You know, is that part of this case? Well, that was never part of this case. This case is all about process. And my client actually voted for Brexit. And that comes as quite a surprise. Well, there you are, you're expressing the surprise.
Well,
that he voted for Brexit. It's all about process.
Yeah, so one of the other complainants, in fact, was on the other side of the issue. My final question is, what has this experience been like for your client?
In terms of what's happened, I think it would be fair to say is that when this process was started, no one was expecting this reaction, particularly in relation to the first instance decision of the divisional court. I don't think anyone was really expecting the reaction to that. As we know, headlines in papers suggested that the judges who'd made the decision were enemies of the people, and no one had really expected that strong reaction. From his point of view, he has kept a very low profile. He hasn't given interviews. He's kept a low profile, whereas Gina Miller has really taken a stride into the public sphere. He hasn't, and he had hate mail, just as everyone has had in this process. And of course, it's very disturbing to get that hate mail. And importantly, is that really, it's a sad day when people are receiving hate mail. Some people have to have bodyguards sitting in the court with them because they're asserting their rights, their entitlement to go to the court and say, this is the right answer to this question, does Parliament have the power, the sovereignty? And all they're doing is exercising that right. But so why do we have to have a position where they are protected by bodyguards as they do so?
Unfortunate indeed. David Greene, thank you so much for speaking on behalf of your client. I appreciate it. Let's bring in our panel now. In London, Michael Patchett-Joyce. He's a lawyer at Outer Temple Chambers and specializes in UK and EU laws. In Edinburgh, Scotland, Simon Pia, a journalist with The Scotsman and a former Scottish Labour Party media advisor. And in Dublin, John McGreene, Director General of the British-Irish Chamber of Commerce. Welcome to all of you. Michael, I'll begin with you. Were you surprised by this court decision?
No, I wasn't surprised by the court decision. I thought that the reasoning of the divisional court at first instance was clear and was right, and I'm not at all surprised that the Supreme Court have upheld the divisional court. Of course, the Supreme Court decided by an 8-3 majority, whereas the divisional court was unanimous. But I'm not surprised at all by the Supreme Court decision.
Simon, you?
No, I wasn't surprised about it at all, but one aspect of the ruling yesterday that did slightly surprise me was the unanimous decision to ignore what is called the Sewell Convention, which was incorporated into the statutory book in 2016 in the Scotland Act, which would mean that the Scottish Parliament, the Northern Irish and the Welsh Assembly would have a say, and this seems to have been ignored. And as to be predicted, once this happened, the Scottish Government, Nicola Sturgeon, the First Minister and the Scottish Nationalist Party are immediately crying foul and demanding that Theresa May takes into consideration the Scottish Parliament's concern. The Scottish Parliament, she's going to put a motion before the Scottish Parliament because if it is ignored, voting on triggering Article 50. But this all adds to the possibility of her calling for a second independence referendum in the UK for Scotland to become a separate state.
And we are definitely going to revisit that issue in just a moment. That's a very important part of the story as well. John, your reaction to the court decision?
Well, I think, as has been said, the process is really about the process rather than the underlying decision. There's a high degree of respect for the fact that the UK people, by majority, even if small, did vote to leave. There are many sublines under that, as has been said, about the regions, Scotland and Northern Ireland not least. So what our reaction to yesterday's step in the process is that at least it adds further clarity, just as Mrs May's speech last week added clarity where there had been deep lack of clarity. We're clearer and clearer about the process steps now are towards the commencement of negotiations, which will be extraordinarily important and deeply significant for all the participants across these two islands of Britain, comprising England, Wales and Scotland, and this island where I'm coming to today from, and that comprises the Republic of Ireland and Northern Ireland, and everybody in these parts of the world are deeply affected by what happens next.
Michael, what precedent does this court ruling set? Not necessarily politically speaking, just legally speaking, what type of precedent does it set?
I think that the two words which have been used so far, talking about process and also a question that you posed about ambiguity, provide the key to answer your question. This is about getting the constitutional process correct. And David Greene was absolutely right to say that that was at the heart of this judgment. It was the ambiguity really arose because of the complexity of the subject matter. And the courts, particularly the Supreme Court, went right back through the historical development of the royal prerogative and also of the United Kingdom's accession to and continued membership of the European Union, right the way from 1972 through to 2016, 2017 now, of course, to really combine those two strands of law and legislative thread, so that it was an extremely complex and nuanced analysis that the Supreme Court undertook. Just to come back on a comment that's already been made about this so-called Sewell Convention. I don't think it's right to say that that has been ignored because it was considered both by the majority 8 members of the Supreme Court and also by the dissenting judges in the minority. It's right that they were all unanimous in saying that Scotland, Northern Ireland and Wales do not get a separate standalone say in this process, but they said it for good reason.
Okay, actually, I think this is a good time to bring up how different parts of the UK voted. As you remember, the referendum results were very close in June, but while they showed an almost split vote, the map doesn't quite reflect that. People in Scotland overwhelmingly voted to stay in the European Union. Voters in Northern Ireland also wanted to remain in the bloc, and now the Supreme Court has ruled that they still won't have a say in the UK's future. Tuesday's decision specifically denies the Scottish, Welsh, and Northern Irish parliaments a veto in the matter. And there's been renewed talk of a second Scottish referendum to decide if they want to stay part of the UK. And that is what you were talking about, Simon. Do you think that's going to happen?
I think it'll happen at some time. I couldn't put my finger on what the timescale is. And to be quite honest, Nicola Sturgeon and the Scottish Government, the Scottish Nationalist Party, they do not want a quick referendum for a simple reason that they're not confident they would win it. But what they do want, and what part this adds to their campaign, is they want... Theresa May came up to Scotland shortly after she became Prime Minister, and she used the words that Scottish Government, Scottish Parliament, we are equal partners. Now this ruling, no, it was correct that the Supreme Court did not ignore it, but they shoved it backwards towards Theresa May and saying it wasn't something that they would rule on, the Sewell Convention. But also David Cameron as well trumpeted after the Scotland Act in 2016 that brought in the Sewell Convention, put it on the statutory on the book, that the Scottish Parliament was the most powerful devolved legislature in the world, one of, if not the most. And how this is being interpreted in Scotland, it depends, of course, on Theresa May's reaction. But the Lord Neuberger was basically saying yesterday, it's up to Theresa May to decide on that. The courts aren't going to rule on this. But in Scotland, it's not just the nationalists are saying it is part of the bigger argument. And fair enough, if the UK Supreme Court's not going to rule on it, the government has to react to it. And even people who are unionists would feel that this is a bit of a snub to Scotland if Theresa May does not take into account the Sewell Convention.
Okay, let's talk about Northern Ireland, for Ireland that is, for a moment, pardon me. EU membership is integral to the very fragile ceasefire settlement. What might, with Sinn Féin, what might the ramifications of this be, John?
Well, first of all, if we take the Northern Ireland perspective, so a majority of people in Northern Ireland who voted in the referendum on 23 June last year voted to remain. And the reality is a great many people in Northern Ireland have felt for some months that their representation of their case on the implications of the Leave vote, which is the democratic majority vote of the UK, that those implications were really not taken on board at an earlier time. And that mirrors reaction not just in Northern Ireland, but obviously in Scotland, in Wales, where people are now beginning to realise the impacts, and in English regions as diverse as London and Cornwall, for instance. Be that as it may, the reality today is that Northern Ireland, for instance, exports 1/3 of its milk every day across the border into the Republic of Ireland to be processed in the south, and then the outputs of that process are in some cases repatriated back into Northern Ireland in the form of exportable cheese or butter and such like. World Trade Organization tariffs on dairy cross-border in that situation are as high as 55% in both directions. So clearly people are beginning to realise that that really doesn't make that market look very viable anymore. And in the Republic of Ireland, the concerns that regardless of the Republic of Ireland's bulletproof allegiance to its membership of the EU, that we need very strongly that the EU takes on board and accommodates the realities of Ireland's distinct position peripherally, geographically, and its interconnectedness with trade and people interactions across these two islands. So we're at a time when the implications are being taken increasingly on board, and in the aftermath of Mrs May's May's dispensation, if you like, last week about what the UK government is asking for, we know just how challenging the road ahead is going to be.
Michael, what does this white paper need to say?
It probably doesn't need to say very much, because no one knows what is going to be in the bill which will be brought forward to enable Article 50 to be triggered. It's highly likely that it will be a very short bill indeed, which will simply be an authorising measure for Theresa May and for the Secretary of State for leaving the European Union to trigger Article 50. Now, the detail of working through and all the complexities which have just been touched on are separate and distinct from the process of triggering Article 50. So I think that the white paper will probably be a very short document indeed, and given that the government is saying they're going to stick to their timetable of triggering Article 50 by the 31st of March this year, then one would expect that it will be a minimalist approach.
Let me read you something from The Economist. It says that Brexit will create risks and ambiguities for which no clear precedent exists, and such a volume and tangle of them that attempting to muddle through could result in paralysis or disintegration. Simon, do you see that this process, since it's so unprecedented, could lead to more legal landmines that have not been uncovered yet?
Yes, I think what I've been referring to regards Scotland is, because constitutionally the UK is evolving towards a more federal status, you could almost describe it as, than the actual law, and the law has not caught up with that, and the politicians are saying one thing. It's quite understandable why the law is trailing along behind it. In the meantime, the complexity that awaits Theresa May, as the previous panelist has said, it will be a minimalist white paper, because I don't think, and I'm not that politicians agree with this, and many media commentators, the government isn't really sure what its stance is going to be on specific issues regarding the negotiations. One good thing about what has happened, I believe, with the UK Supreme Court passing it back to Parliament, is that the parliamentary input will in the long run be very helpful to the government. The amendments that will be tabled as well will help set the government in the right direction. The Scottish Nationalists are going to table 50. They will be considered unhelpful in many respects, but a lot of these amendments will include a wide range of the political spectrum doing some of the heavy lifting for a government that still is not sure what exact direction it's heading for Brexit. It will pass through Brexit, but in what form, we still don't have much of a clue.
John, I think that's a good point that Simon has brought up here. Do you think that this is actually a good thing, that Parliament will have some say-so in shaping this going forward?
Oh, undoubtedly, in the sense that the democratic process which underlines all of this matter has to be given the maximum room to give legitimacy to all of this, because there is a very fragile base under this overall process stemming from the reality, the democratic reality, that the margin of victory, shall we say, for leave, which is respected, was actually just 52 versus 48 to remain. And there will always have been a hankering that didn't really give the mandate for such a now known extreme exit prescription as is on the table. So any additional airing of the matter that allows democratically elected representatives of the people to have their say has to be undoubtedly a good thing. Equally, it does add to the hazards. And it does ultimately shape the credibility of the UK position in its negotiations with the EU 27, who will read just the degree to which Mrs May has a UK-wide mandate for what she's asking for.
Thank you to all of my guests. Appreciate your time, gentlemen. Michael Patchett-Joyce, Simon Pia, and John McCrane. And thank you for watching. You can see the program again anytime if you go to our website, aljazeera.com, for further discussion. go to our Facebook page. That's facebook.com/AJ Inside Story. And you can join the conversation on Twitter as well. Our handle is @AJ Inside Story. From me, Richelle, Carey, and the entire team. Bye for now.